The Supreme Court has put the colonial era sedition law on hold till the central government finishes its exercise to re-examine and review the provisions of Section 124A of the IPC. Centre had initially defended the colonial provision but later told the apex court it was reviewing it. What is the sedition law? Section 124A of the IPC, where the sedition law is enshrined, was introduced by the British government in 1870 to tackle dissent against colonial rule. Section 124A defines sedition as whoever by words either spoken or written or visible representation brings or attempts to bring into hatred or contempt or attempts to excite disaffection towards the government established by law shall be punished with imprisonment for life, to which fine may be added. Now, these are the 5 key things that you must know. Number 1. The petitioner. Retired Major General S.G. Bombadkere had challenged the constitutional validity of the sedition law on the grounds that it has a chilling effect on speech and poses an unreasonable restriction on the fundamental right of free expression. His plea was to strike down the draconian law. Number 2. What the Supreme Court said. The Chief Justice of India, N.V. Ramana, said that it is clear that Centre agrees that rigors of Section 124A are not in tune with current situation, and thus Centre may reconsider it. The court is to balance civil liberty and sovereignty of the state. This is a difficult exercise. Number 3. Pause on pending cases. The Supreme Court has directed both the Centre and states to keep in abeyance all pending trials, appeals and proceedings with respect to the charge framed under Section 124A of the Indian Penal Code. The court said that it will be appropriate not to continue to use the provision by various governments, and added that the court hopes and expects that the Centre and the states will refrain from registering any FIR, continuing any investigation or taking any coercive measure by invoking till the review happens. Number 4. Law being misused. Over the years, various people have been booked under this provision of the IPC, including author Arundhati Roy for her remarks on Kashmir, Stan Swami, Hardik Patel, and more recently, climate activist Disha Ravi, Kanhaiya Kumar, Umar Khalid, journalist Vinod Dua and Siddiqui Khapan, among others. Chief Justice N.V. Ramana said that the petitioners say the law is being misused. The Attorney General had also mentioned that the sedition charge was filed in the Hanuman Chalisa case, and if any fresh cases are filed, concerned parties may approach court and court to expeditiously dispose of the same. Number 5. Consider bail. The Centre did a U-turn 2 days after it defended the sedition law and proposed that future FIRs under this section be registered only after scrutiny by a superintendent of police, level official or above. On pending cases, courts can be directed to expeditiously consider bail, it said. Kapil Sibal, who was appearing for the petitioner, said over 800 cases of sedition have been filed across India and 13,000 people are in jail.